We have WEA employees at Bates. So, of course, you know, they have an interest in education, and having you know, their endorsement is something that I'm grateful for. You know, any organization that gets behind you when you're running for office, especially first time. I've never run for anything before in my life. So when people step up and say, you know, we like your ideas, we think that you bring the kind of values to the court that we believe in, we're going to support you, and we're going to ask our membership to support you, that's great. I hope you ask your readers to do the same thing. I'd be very grateful for that.
One of the things I know you time, I'm not too clear on both of your positions, and that is on gun rights.
Well, he'll shoot at this one anyway, because I wrote about a month ago on it. We wrote an opinion from our Washington State Supreme Court. It involves the prohibition on kids under 18 possessing guns.
Right.
That's a statute, and it has two exceptions: home or hunting. First, the court wrote in a majority, which I joined, that the Second Amendment of the U.S. Supreme Constitution applies to the states. That, of course, 2 weeks later or 3 weeks later, the U.S. Supreme Court saw the same thing. So we know that. I went on to write, no, there's more to this story than that. The Washington Constitution, not only do we not have any militia clause qualifier, but our Washington Constitution says you have an individual right to keep and bear arms in defense of yourself. It says that half step better, which I was earlier alluding to when I was talking history with you. I mean, we were settlers and homesteaders, and so guns have always been, and so it's better protected in the Washington Constitution. I went on to write, if this is a fundamental right, and we now know from the U.S. Supreme Court it is federally, and it is statewide, that we have to have an analytical framework analogous to those that we apply in First Amendment and other fundamental cases, which is, you've got to be, I said, strict scrutiny. Not to say that you can't prohibit gangbangers from having guns and driving around in cars, but that's what you've got to prohibit. You should not have a blanket prohibition. So I suggest, and then I had fun writing the history too. After all, since it's an 18-year-old statute, I went back and said, look at all the people who fought for the Revolutionary War, and many of them Congressional Medal of Honor winners, 17 years old, 16 years old. They were fighting expressly for the right to keep and bear arms. And digressed, and I don't know if you've read the U.S. Supreme Court cases, wonderful history of after the 14th Amendment was passed and the efforts to keep certain citizens in the South from having weapons. It's always been part of the civil rights. So I did rant and rave a little bit on the subject, but the analytical point was when you identify a fundamental right, you have to be really careful in analyzing efforts by the legislature or regulatory agencies to infringe that right. And so that was my C's concurrence slash dissent.
You made a point, Stan, that Justice Johnson was stating that children should have the ability to have concealed weapons.
That, if you read the C's decision, that is the upshot of the decision. Just read it. Well, here's the deal. You know, my family fought in the Revolutionary War, came to this country before it was a country. They moved west for land, settled in the Ohio Valley, fought in the Civil War. There have been Rumbaghs fighting in wars across the span of time in this country. My cousin lost his life in the Vietnam War. So I grew up on a farm. We've always had weapons. I've always gone hunting since I was a kid. My grandfather showed me how to safely use weapons. I don't have any heartburn at all. But there are obvious restraints on any right. You can't keep a surface-to-air missile in your garage, just as you can't print libelous material in your newspaper. So everything has an end point. My problem with the decision of Zayas was it leaves the door open. Well, the statute that was being criticized was one that said minors under the age of 18 cannot carry around concealed weapons except for the exceptions that Justice Johnson noted. So when you have 17-year-old kids driving around with loaded guns under their car seat, when you have the ability, I guess he talked in the opinion about 13, 14-year-old kids bearing arms, presumably that is something that would be within the purview of their freedom to do, to take loaded guns into parks or into public buildings. I think that you need to give the police every weapon, so to speak, that they can legally to reduce the carnage that's taking place with young people in our cities and towns across the state. We're not fighting the Revolutionary War with muskets anymore. We have drug wars, we have gang wars. The blood of our children is spilling on the sidewalks and the street of every city and town across this state, and it's terrible. And so when you pass a law, and you say, well, you have to have strict scrutiny attached to anything that prohibits or curtails the right to bear arms, I don't know what more compelling governmental interest there is than to restrict concealed weapons from our kids. There's a difference when you're hit 18 years old and you reach the age of majority. A lot of things change. But I think you can go a long way with stopping the violence in our streets and the needless and senseless killing of our children if you have available to the police some method by which they can take the guns away from these kids. That's all.
Let me, quick, can I get in one question?
Okay, Karen.
Let me ask you a quick question that I've sat in court several times in the last 18 months and listened to defense attorneys eloquently go on and on and on and on about how allowing the media access to information imperils their clients' rights to a fair trial because we'll publish it by law. However, they totally ignore the other piece of our judicial system, which is that a trial not only needs to offer the defendant the right to a fair trial, it also needs to offer the public the opportunity to observe and evaluate what happens in that trial process. And I'd like to hear from each of you how you think you balance that when you sit down in the court. How does a judge balance that?
Well, I'll take a shot. I don't think there's really an awful lot of balancing. As you note, the court may be just catching up to some of this, but our Constitution provides that the justice system will be open and public. We have three interests then. We have the open and public part, which serves to sanitize, to make the whole process honest. That's what it's all about, and that's why it was written that way. We have the rights of the defendant, and then the victim or the jury rights. The last two cases that our court has written that dealt with this issue, one was MoMA and one was Strode, and where they had excluded the public for some or part of the jury selection was. And the short answer is you can't exclude the public, by which I also include the news media, because the sanitizing effect, and it's constitutional. I just don't think you can weasel around a constitutional mandate